Wow, we're going to be a full house here. Just wait for everybody to sit down here. Good afternoon. Welcome to the Duke Law Journal's annual fall lecture. My name is Adam Doerr, and I'm the editor-in-chief of the journal. Today, I'm pleased to introduce Professor Eric Posner. Professor Posner is the Kirkland and Ellis Professor of Law at the University of Chicago, and he's a graduate of Yale University and Harvard Law School. After clerking for Judge Williams on the D.C. Circuit, he worked at the Justice Department's Office of Legal Counsel. He then began his academic career at the University of Pennsylvania Law School, and he joined the faculty of the University of Chicago in 1998. Professor Posner writes and teaches in the areas of international law, contracts, foreign relations law, cost-benefit analysis, and bankruptcy, among others. He has co-authored books and articles with Adrian Vermeule, Cass Sunstein, Matthew Adler, and John Yoo. Most recently, he is the author of a book, The Limits of International Law, with Jack Goldsmith. Today, Professor Posner will be discussing his forthcoming Duke Law Journal article, Political Trials in Domestic and International Law. Professor Posner will speak for about 30 minutes, and then we'll have time for questions. So without further ado, please welcome Professor Eric Posner.
Thank you, Adam. I gather Jeff Stone was here a few days ago. Did many of you see him and hear? Yes, a few of you did. So I'm not going to say exactly the opposite of what Jeff said in his talk, but it's not going to be entirely consistent with his views, and you can make up your mind who's right. I'm going to talk today about political trials. And before giving you a definition of what a political trial is, I want to give you some examples. And the examples I'm going to give you are not ones that everybody agrees about. So these are trials, famous historical trials, that some people have called political and other people have denied were political. So start with some international trials. The Nuremberg trial itself, maybe the most famous political trial of all. At roughly the same time, the Tokyo war crimes trial, often called a political trial. And then, much more recently, the International Criminal Tribunal for the former Yugoslavia. Now, it's somewhat more ambiguous whether this was a political trial or not. I'll talk about that later in my remarks. Next group of trials are transitional trials. These are trials that occur in new democracies that are just emerging from an authoritarian past. There were, well, with one exception. So the first one, the most famous case, perhaps, or the first, is the trial of Charles I in 1649. So this was not a new democracy, but Charles I was tried for being a tyrant. So this was a political trial. After the American Revolution, there were some trials of loyalists that were generally considered political trials. The trial of Louis XVI in 1792, another political trial. And then more recently, there have been a wave of transitions, or several waves of transitions. We can start in the 1970s in Southern Europe, Greece and Spain, Portugal emerged from authoritarian past. There were some trials in Greece. And then in the 80s and 90s, there were transitions in Eastern Europe, South Africa, Latin America. And in some of these places, there were trials of leaders of the old regimes or officials of the old regimes. And many of these trials might be regarded as political trials. Now, generally, though, when people talk about political trials, they mean domestic political trials. And let me give you some examples from the history of the United States, although obviously the United States is not the only country that has had political trials. In fact, the United States has probably been better than most countries. Certainly, and many of these are controversial, but I want to go through them just to give you a sense of what the debate about it. Certainly, the trials of under the Sedition Act from 1798 to 1801 are regarded as political trials. These were trials of Jeffersonian Republicans, often newspaper editors, essentially for criticizing the Federalist government. There's another political trial, the impeachment of Samuel Chase in 1805, this time under Jefferson. Chase was a Federalist. Although the impeachment ended in acquittal, it's generally regarded as a political trial. Chase was being tried for his political beliefs. Arguably, the trial of Aaron Burr in 1807 was a political trial, but let's skip to the Civil War. There, the Union did have a number of trials of Southern sympathizers, including most famously Vallandigham. These were people who were not necessarily helping the Confederacy in the war effort, but did oppose the war. They were Northern Democrats to some extent, or some Northern Democrats. They were tried under martial law. The impeachment of Andrew Johnson was a political trial. There were trials after the Haymarket riot in 1886 that were arguably political trials. During World War I and around the end of it, there were numerous trials of opponents of American policy in World War I, including most famously Eugene Debs, who was a presidential candidate. There was arguably the Sacco and Vanzetti trial was a political trial. Many people believe that the murder charges were trumped up and they were being tried because they were anarchists, that their political beliefs were considered undesirable. Some trials of Nazi sympathizers during World War II, but more famous were the trials of the communist sympathizers during the 40s and 50s, including Eugene Dennis, Hiss, arguably. Many of these people were tried for violating the Smith Act, which illegalized advocacy of violent overthrow of the American government. There was a series of trials during the Vietnam War, which were arguably political trials, again, trials of opponents of the administration and of the war. And then most recently, the impeachment of Bill Clinton was a political trial. And when I say that, I'm not expressing a view of whether it was good or bad. It's just a fact that some of the charges in the bill of impeachment were political charges. You have brought disgrace on the office of the presidency. There was no law that prohibited that. It was a political charge, and in fact, impeachments are frequently political in the purest sense. So what is a political trial? Here's a definition, and it's a rough definition because people use the term in different ways. But let me stipulate the definition as follows. A political trial occurs when the government uses the judicial process against its opponents. And I include foreign enemies and internal dissidents. Okay, so again, when the government uses the judicial process against its opponents who have not violated formal, generally enforced laws, or have violated only formal laws against political dissent. Okay, so two situations. There might be a law that says you can't criticize the government. A trial under that law would be regarded as a political trial. The second, those laws are not generally permitted in this country, so the second and more frequent case in the US involves some general law, incitement to riot or obstructing the draft. But people think, at least critics of the trial think, that the reason for the trial is that the defendant has undesirable political beliefs, not that he actually violated the law or did so in any way that distinguishes him from anybody else. So people tend to be hostile to political trials, and I think the hostility is appropriate generally, but not always. And let me, to try to persuade you of this, cite the most prominent discussion in the literature, which is Judith Sklar's. Judith Sklar was a political scientist at Harvard, and she wrote a book called Legalism. And the book is all about criticizing what she calls legalism, which is this ideological commitment to the rule of law that is indifferent to the values that the rule of law is supposed to serve. But what's interesting about Sklar's discussion is that she defends Nuremberg and she criticizes the Dennis case. The Dennis case is one of the Smith Act cases. So about Nuremberg, she says, the Nuremberg trial was clearly a political trial. It violated the rule of law because, after all, there was no law that the leaders of Nazi Germany had violated. The law was invented for the occasion. Nonetheless, she thinks the Nuremberg trial was good because it advanced the rule of law in international relations. It helped create, she argues, a system of international law that is desirable. She's impatient with what she calls legalists, people who think, well, if any trial violates the rule of law, it's bad. But then she turns to Dennis, and in Dennis she criticizes the discussion of Judge Hand at the circuit level. Judge Hand says, look, Dennis is working for the communists, and the communists are working for the Soviets, and the Soviets are an external enemy, and we can't afford to have people like this roaming around helping the communists, so it's okay to convict him under this law. Sklar says that's wrong, but the reason she gives, if you read carefully, is simply that she disagrees with Hand's analysis of the factual situation. Hand thought that people like Dennis were a threat. Sklar, writing a decade or more later, thought they were not a threat, that they were harmless people. And so she argues that prosecuting people like Dennis just corrupts the judiciary. But presumably, well, so the question is, how does she reconcile these two views, that Dennis is wrong, but Nuremberg is right? And ultimately, all she says is that in a liberal democracy, political trials are just forbidden. They're just never acceptable. But she doesn't explain why that should be the case if they can be acceptable at the international level. Now, I'm going to talk more about this theory, but first let me give you a little bit of legal background, very briefly. There's no constitutional law that says you can't have a political trial. In fact, as I mentioned, impeachment is explicitly authorized by the Constitution. And although they use this term high crimes and misdemeanors, the general understanding over the years, based on impeachments of judges as well as of presidents, is that political charges are acceptable. You can impeach a judge for disgracing the judiciary, whatever that means. And that happens. Nonetheless, there are significant bars on political trials. The most important is the First Amendment, of course, which makes it unconstitutional to enact laws that simply criminalize dissent. Because of the First Amendment, most of the arguable political trials in American history involve a little bit of cutting of edges. So often what's argued is that the US government is faking evidence or trumping up charges. And for this, the Due Process Clause is supposed to come into play. The Due Process Clause would make it difficult for the government to prosecute a political dissident under a generally applicable law, for example, unless the political dissident has actually violated it. A final important constraint on political trials in the US Constitution is structural, and I actually think this is the most important constraint, that the executive, Congress, and the judiciary all have to cooperate. So if Congress wants to go after somebody that it doesn't like, it can always pass a law that makes life difficult for that person, but if the executive doesn't want to enforce the law, the political trial will not occur. If the executive wants to go after a person, Congress can interfere with the executive as well by not enacting laws that would allow the executive to prosecute the person. And finally, of course, the judiciary can prevent political trials from occurring simply by having high standards of proof and high standards of evidence and so forth. Okay, but so the Constitution is there in the background, but it doesn't reliably prevent the government from conducting political trials. So how should we think about political trials? I think the conventional view is simply that they're wrong, and I think the conventional view might be described in the following way. So our system can be called something like liberal legalism. What does liberal legalism mean? Well, it has two components. The liberal component means that we're committed to a system of political competition. So the government is not allowed to criminalize political opposition. The legalism side means that we're devoted to the rule of law or due process, which means that you're not allowed to be thrown in jail unless you have violated a law that's been enacted in advance and is generally known. You've had a hearing, you've had a chance to contest the government's case. An independent judge hears your case. Maybe you have a jury as well. In this country, you have a right to a jury, not in other countries though, and so forth. That's the legalism component. Now, why are we committed to liberal legalism? Well, there are various philosophical arguments for this. I'm going to put these aside. You probably are familiar with them in any event. But basically, the idea comes down to the notion that it's simply unfair to put people in jail for crimes they didn't commit. And it's wrong politically, and it's wrong as a matter of political morality, to prohibit political competition. I want to approach liberal legalism from a different angle, from an instrumental angle. And I want to argue that, that liberal legalism could be understood as a set of policies that would be adopted even by a Machiavellian state, a Machiavellian government that sought to maximize its power. So why would well, you might think an authoritarian government or a Machiavellian government that wanted to maximize its power would do so by simply, throwing all of its political opponents in jail and doing whatever it wants, enacting policies that advance the interests of its supporters and harm its opponents. But there's another view, and the view goes like this. Even authoritarian governments, even Machiavellian governments that want to stay in power, realize that they can stay in power only if they maintain the support of the public. Now, public support is often difficult to get because the public will only support a government, and an authoritarian or a democratic government, if it thinks the government is serving its interests in some general sense. Now, one way the government serves people's interests, one of the, perhaps the most important way, is by providing security. Both internal security, in order to minimize crime, and security against external threats, foreign countries that might be hostile. Any country that is unable to provide internal and external security, any government that is unable to provide internal and external security to its citizens will eventually fall. So, how do governments do this? Well, one way they do this is that they have criminal law, which they try to enforce, and they have they maintain a military and try to defend themselves against foreign countries. But you might say, well, why, returning to internal security, why have courts and so forth? Why not, whenever you see somebody commit a crime or think someone's going to commit a crime or think that someone's of the type who might commit a crime, you just throw them in jail, and that's the end of the story. And the problem is that if a government does that, the public doesn't know whether the person that the government is throwing in jail is in fact a threat to public security or merely a partisan opponent. And I'm going to linger on this distinction between a person who is a threat to public security generally and a person who's a threat only to the government that happens to be in power, perhaps because he has better ideas than that government has, perhaps because he's charismatic, perhaps because he has his own body of support. And what the government needs to do time and again when it chases people down and throws them in jail is persuade the public that the reason it's chasing this person down is that he's a threat to them, to public security generally, and not that the person is just a political opponent. So what the government is actually doing is and here's again the liberal part and the legalism part. The liberal part is the judge is saying, look, they're not really saying this, but we want to maximize power. They won't say that. But implicitly, we want to maximize power. But we understand that you're only going to support us if you think we're serving your interests. One way we'll show that we're serving your interests is we'll tolerate political opposition. Because our ideas are better than theirs are, and we're more competent people than they are. And so we're not afraid of them. And we'll even have elections because you'll agree with us when it's time to have an election. So we tolerate political opposition. In addition, we respect legalism, or the rule of law. And the reason is that we want to convince you that whenever we put someone in jail, it's because the person is dangerous, not because that is dangerous to the public, not because he's a partisan political threat to us. And so trials and independent judges and rules of evidence and all the rest are all designed to enable the government to send this message credibly to the public. So this instrumental theory of liberal legalism is not completely incompatible with the philosophical view. The philosophical view is just that liberal legalism is normatively attractive. The instrumental view adds that it could be stable. That is, it could actually come into an existence in a world in which, for most of history, the people who obtain political power are not philosophically committed to liberalism or legalism. But when and if they find it in their own interest to implement these ideals, they might do so. Perhaps they will do so. And now I might go farther than the philosophical perspective by saying that this may indeed be, in fact, the basis of liberal legalism in this country and other countries. This is why it's stable, perhaps even more stable than authoritarian systems, more successful. But if it's right, it has certain implications for trials. If liberal legalism has instrumental value for governments in the way that I've described, then the governments will depart from liberal legalism when it serves their interests. And there are really two ways that there are two reasons why a government might depart from liberal legalism. And by depart, I don't mean abandon it completely and become a dictatorship. I mean adjust it at the margins, which might mean a little bit of censorship rather than complete censorship on the liberal side, and it might mean some compromises of due process rather than eliminating due process on the legalism side. So the first factor is that there's a new threat to security. This new threat to security is greater than the prior threat, for which liberal legalism is most appropriate. In the face of the new threat, the government realizes that it's got to protect the public, because if it doesn't, it will fall. So it's got to take stricter security measures that violate the baseline amount of liberal legalism that had existed up until then. The other factor is simply that if a government happens to enjoy the trust of the people more than in the past, perhaps because it's been doing a very good job or its leaders are charismatic, then it can also depart from liberal legalism because it already has the public's trust and it doesn't need to constantly reassure the public that it's worthy of trust. But I'm going to ignore this second factor and return to the first, which is the new security threat. So what happens when there's a new security threat? So it's a little bit complicated. So I think the way to think of it is as follows. There's a new threat. Somebody declares war on the country. There are new terrorist attacks. The government responds by taking more aggressive security measures. Part of that involves reducing procedural protections. Now, when the government reduces procedural protections, there's a cost there, which is that it knows that the public will trust it less. Because after all, when procedural protections are reduced, that will give the government the opportunity to pursue its partisan opponents, at least on the margin. That's the whole point, right? And if the government has that opportunity and the public is going to think that it's taking advantage of that opportunity, whether it is or not, it might as well. So it's predictable that during emergencies, you'll see two things. You'll see stricter emergency measures that infringe on due process, and you'll see partisan prosecutions. That doesn't mean the government is going to try to wipe out the political opposition. It just means at the margin, and perhaps as a result, these prosecutions will only be of extremists. Meanwhile, the defendants will exploit this ambiguity, and the defendants will start making political defenses. So they'll start saying, they'll stop saying, I didn't rob the bank, and they'll start saying, yes, I robbed the bank, but that's because the government is unjust, and I'm trying to resist our unjust government. And in fact, that's what one sees over and over again in political trials. Now let me talk a little bit about the evidence. Let me return to some trials. Of course, there's not a lot of evidence one way or the other, but I want to point out a couple things. First, the initial Sedition Act trials of Jeffersonian Republicans were too extreme. In other words, they were an attempt by the government to go after the mainstream political party, the mainstream political opposition, indeed a political opposition which was probably more popular and powerful than the government itself it was. So it was a total failure, and this is what happens when political trials fail. The defendants gain more than the government does. So the government's credibility declined, and the defendants became heroes. They became national heroes. Some of them were elected to office or re-elected to office. One of them was re-elected to office while in jail. And I think people learned from that experience and from the failed impeachment of Chase and the failed trial of Burr that it's not a good idea to try to go after, to use the judicial process against mainstream political opponents. And in fact, it's very hard to find any after that period with two possible exceptions. So the first exception is during the Civil War. Now the Civil War was a civil war. There was immense division. The military trials of people like Vallandigham were trials of something like a mainstream political opposition. But there, the security threat, at least from the perspective of the military, was so high that it was justified. Nonetheless, these were extremely controversial trials. At the time, in the North, people were very upset about them, even people who generally supported Lincoln and the war effort. The other example, arguably, is the Vietnam War era trials. These were against extremists, not mainstream political opponents for the most part, but these were extremists whose views were consistent with the views of a large segment of the public. So these, as a result, were also highly controversial, not particularly successful political trials. But the trials against the extremists, the Nazis and the communists and the sympathizers and fellow travelers, those were generally successful trials. They were popular with the public. And the reason they were popular with the public was that the public thought these people were a significant threat, and they were to some extent. Certainly the movements they represented were significant threats. And the trials did not in any way threaten mainstream political opposition in the United States. So the government was able to retain its credibility. The fact that the government was prosecuting communists or Nazis didn't make people generally think that it would start going after the Democratic Party or the Republican Party generally. Okay. Let's see, how am I doing in time? Oh, okay, so let me talk a little bit now about what I call design principles in the paper. Suppose, so here's the problem, and maybe I can clarify in the following way, that general criminal trials often don't work against people who are public threats, that is, who genuinely pose a danger to public safety, national security. But if you go after them anyway, there's always this concern that the government is actually going after partisan political opponents and therefore undermining political competition, which is at the heart of our system. So one of the questions is there a way that these political trials can be designed in order to resolve this tension at least a little bit? So, one obvious possibility would be, well, why don't we just have laws that say if you're a real threat to national security, then the government can prosecute you and put you in jail, but not if you're just a little bit of a threat, or not if you're just a critic of the government. Well, they tried those laws. In a way, the Smith Act and the Sedition Act could be interpreted that way. That's what the language says in those laws. The Smith Act talks about advocating violent overthrow of the U.S. government. But these laws never really worked because they could be interpreted broadly to sweep in mainstream political opponents. And the political spectrum is a spectrum. So if you're in the opposition and the government goes after people who are a little bit to the left of you or a little bit to the right of you, there's always the concern that after the government has eliminated those people, to move on to you. So these general laws against being a national security threat were never popular and seem impossible today. So what does the government do? It has to use general laws in a selective way, or at least that's what the government has done. So a famous example would be the Chicago 8 trial, where the government went after some particularly influential opponents of the Vietnam War by charging them with incitement to riot, because they were there in Chicago during the riots in 1968, although there's little evidence, I believe, that they actually did incite riot in any sort of standard legal sense of that idea. So what does the government do? So it can engage in selective prosecution. Rather than charging everybody who could remotely be thought to have incited the riot, you just go after the people who are the politically most dangerous people. But that's a bit awkward, although courts do permit that to some extent. But I want to focus on a couple things. First, I think most interesting idea is what judges can do in order to resolve this tension between opposing public threats and government credibility, is allow defendants to make political defenses. So in ordinary trials, you're not allowed to make a political defense. If you're being tried for armed robbery, the judge will just not let you assert as a defense, I was doing it because I live in an unjust country or the government is evil. And when we have political trials, courts have always been tempted to apply the same rule to the defendants. But arguably, that's not a good idea, because sometimes these defendants just hang themselves before public opinion by making their political defenses. The public is concerned about people who are threatening the nation, and they're concerned about government's credibility. It's concerned about the government going after partisan opponents. But the public's not terribly concerned about extremists, people who want to create a communist utopia. So if the defendant in a 1950s era case says, look, I did what I did because I want to create a communist utopia, that's actually going to enhance the government's credibility rather than undermine it. It will show that the government is going after this person not because the government thinks of this person as a serious threat to its political power, but because the government thinks this person is dangerous. For example, he's really a spy, although it's hard to prove. Another interesting way that this tension can be resolved between addressing a public threat and maintaining the credibility of the government is through judicial selection. Now, this has evolved in a kind of a haphazard way, but it's still interesting. In the United States, every judge is a member of one of the two major political parties, I believe, or virtually every judge. And they're selected on the basis of two criteria, competence and proven partisan loyalty. Now, in most other advanced liberal democracies, judges are members of government bureaucracies. And so they're treated more like experts than as partisans. So The nice thing about the American system, of course, the judges are supposed to be independent, but what they will do is guard against partisan prosecutions. Because the problem for the government is at some point, if it goes after somebody merely because he belongs to the opposition party, a judge at the district or appellate level might also belong to that party and not be willing to allow the prosecution to go ahead unmolested. Now, in these other countries, the judges are more like bureaucratic experts, and there's this danger that they will apply the rule of law in a wooden fashion in order to prevent the government from addressing serious threats to the national security, as well as preventing the government from engaging in partisan prosecutions. But in these other countries, because the judges are a member of a bureaucracy, they can be sanctioned by the government. And in Japan, I know, for example, judges who do a bad job are sometimes sent to the remote provinces. And so what's interesting here is the possibility, although I don't know whether there's any evidence, that if a judge allows a Japanese judge allows a partisan prosecution to go through, he will be punished when that party eventually seizes power, if in fact it ever does. Okay, so let me conclude with some comments about the trials of the enemy combatants, and then I want to return to Nuremberg and international trials. So one thing that the courts have done in the United States, which is interesting, and of course very controversial, is they've resisted being complicit in political trials against terrorists, right? So we know that we think somebody is a threat to the United States. He's a member of Al-Qaeda, or he has some kind of associations with Al-Qaeda. We could try to prosecute him in a regular court, but if we do that, we need evidence, and we have to prove that he committed a crime. That turns out to be difficult to do, often. So what we might try to do is convince the judge, well, this guy is just a dangerous person. He's a member of Al-Qaeda. We picked him up in Afghanistan. You should let us throw him in jail. Judges have not been willing to do that. Okay, they used to be willing to do that. In other countries, they've been willing to do that, but they're not willing to do that today. But what they are willing to do is allow the government to circumvent the Article III judiciary altogether by setting up these military commissions and detaining unlawful combatants. So there's a question why judges would be willing to do this. In one way, they protect themselves, I guess, from having to be complicit in trials that relax the rules of due process. But they might just think, look, the threat posed by Al-Qaeda is so serious that we can't insist on regular judicial process. And we're not terribly worried that the government's going to lose its credibility, at least so far, because whatever you think about the military commissions on Guantanamo Bay, they're a bipartisan effort, essentially. They're not being used to target Democrats, or not yet anyway, or the allies of the Democrats. They're being used against these foreigners, right? These people who are not Americans, at least on Guantanamo Bay. And so there's much less of a concern that these are political trials in the sense that I mean, has a strictly negative meaning, the partisan political trials against the Democrats in this particular case. Okay. International trials. So what was going on in Nuremberg anyway? People have written about this endlessly. So this is what I think was going on. The United States was trying to change the rules of the game for international relations. It wanted to say, whatever the rules were in the past, they have to change. We can't have a war again like World War II. So how should they change? Well, we can't have aggressive wars, and we can't allow people to massacre their own populations. Now again, this wasn't the rule at the time, and so it was a little bit awkward to try the Nazi defendants for violating these rules, but they did so anyway. And this was relatively popular, I guess, although in fact public opinion data from the time are ambiguous. In terms of this trade-off that I've been talking about, what the US wanted to do was convince the world that there's a difference between legitimate competition between different countries and illegitimate competition. Legitimate competition might include economic sanctions and various types of coercion, perhaps, but not aggressive war. That was going to be illegitimate from now on. If you wanted, you just couldn't conquer another country to obtain its territory. nor could you massacre your citizens. That's part of that's the new rule. But the problem was, and here we get to the credibility problem. Why was it credible for the United States to assert that these were going to be the rules, that in fact it would enforce these rules, or that it would comply with these rules, or that these rules could be sustained in the international arena in the future? After all, nobody paid attention to anything like these rules in the past. And here was the problem of credibility. Maybe the United States simply was taking vengeance on these guys, despite Jackson's words to the contrary. And all of this stuff about aggressive war, this was just propaganda. So the solution was to have a trial, to give the defendants a chance to persuade the world that their system was actually better than the system that the Americans were proposing. And what was ingenious about this was that nobody liked the Nazi system. It was a terrible system. It was bad in Germany, and it was bad everywhere else. And so it worked brilliantly to give these people a chance to defend themselves. It worked much less brilliantly in Tokyo because the Japanese weren't as bad as the Germans. It really comes down to that. The Japanese aggression was in an incredibly complicated way mixed up with America's own aggressive action in the Far East. And although the Japanese committed all kinds of atrocities, so did the Americans against Japan. So that war, the message was much muddier, and the Japanese people did not learn the message that the Americans intended to send, which was, from now on, these are the rules of the game. They just thought, well, these guys won, and they do what they want. Whereas in Germany, arguably, the message was, here are the new rules. The new rules: no more aggressive war, no more massacres of one's own civilians. Whether these new rules actually have been successful and whether they will succeed in the future and have since Nuremberg is a more difficult question. But the point was that having this trial, having some due process, although not having complete due process, which of course would have made the trial impossible, was a way to enhance the credibility of America's story. Okay, so I'd be happy to take some questions. Yeah.
You described two extremes in terms of political trials and then kind of a fuzzy middle. And as I understand it, the extremes are, massively unpopular political movements such as the Nazis, and their political trials are effective because the people will turn against the Nazis. The other extreme is a trial against a mainstream party like the Democrats, and there it won't be successful because it will just empower the Democrats. And then there's this fuzzy middle territory, which you suggest the Japanese. I would also put Eugene Debs in that area. And I'm not convinced, however, that you have drawn clear enough dividing lines so that someone who's trying to decide whether they're going to have a political trial knows which zone that they're in. The Debs case in particular, I think is instructive, because what you had in Debs is you had a third party, not a party that was probably going to come into power, but some that had some support. And it was also a party that was espousing what it was at the height of the Lochner era. Whatever subsequent events have since shown many flaws in socialism, but in the 1910s, what the socialists were saying made a lot of sense considering what the mainstream view was. The result of the Debs trial, of course, was that the socialists were massively decreased, that they became a non-entity, and it wasn't until the total collapse of our economic system that we were then able to see a resurgence of a movement against Lochner. So I guess what my point is, in that case, in those fuzzy middle cases, there really was a harm caused to society. It wasn't that people rallied around the socialists and we wound up eliminating Lochner. We wound up having spent 15, 20 years more before we got out of that era. This is a rambling question, but I guess if I could put it, I guess if I could put it down into one sentence, it would be simply, what are those dividing lines? How can you tell when the trial is going to be bad, as it was in the Debs case, and when it's going to be, better, as it was in, say, the Nuremberg case?
Well, I think it all comes down to whether there's a political consensus or not. So the more that there's a political consensus about the general rules of the game, the easier it is to make the decision whether to have a political trial or not. And in those situations, if you have a political trial, a trial of a mainstream opponent, it'll be a disaster. And if you have a trial of an extremist who's simply a threat, it could very well be successful. When the country is divided, and at the extreme we have civil war, it's impossible to know what to do. And the trial itself just becomes a new forum where the political battles that divide the country are played out. So this was particularly true in the Civil War, and it was true to some extent during the Vietnam War. In the Debs case, the teens and 20s are complicated. There was a lot of labor support for socialism, but I think the mainstream view, the majority view, more than a majority, the vast majority of the country were not happy. Were not happy about this type of the platform that Debs had, or his opposition to World War I. So I think that, my sense is that the trial was successful also, that in the narrow political sense, that it did weaken the socialists, although it may have helped Debs in some sense in his electoral ambitions, I guess, or at least in his attempt to spread his message. But that's what one would expect in the difficult middle case, that you've got a muddy case, and the outcome is complicated to evaluate.
Quick follow-up. I guess my point is that in 1910, or the 1910s and 20s, weakening socialism wasn't necessarily in the nation's interest because, while socialism had plenty of problems, the Lochner era had at least as many problems, and so socialism could provide a counterbalance to to that dominant legal regime. So, I mean, yeah, the Debs trial was successful in that it allowed the government to weaken the movement it wanted to weaken. My point is simply that normatively, I don't think that was a good thing.
Well, yeah, so when I talk about what's good or bad, I'm taking as a baseline something like what the public thinks is in its interest. And if we disagree with what the public thinks is in its interest, then we're going to be highly critical of all kinds of ordinary trials that respect the rule of law, because the law that's on the books will reflect the public's misconception about what's in its own interest. So I'm not making any kind of normative claim that political trials are good or bad. I guess the only normative claim I want to make, and I want to limit this to security, which is a little bit easier and simpler than the sorts of economic policies that you're referring to, is that it's good to use a trial against a person who is a genuine threat to national security. And even if that involves relaxing the rule of law in that setting. So it's a narrower claim than the one that you implicitly attributed to me. Yeah, back there.
You mentioned that one of the purposes of the political trial was the sort of rhetorical, almost Foucaultian function of controlling the public to a degree, or indoctrinating some sort of idea or message into them. And I wonder how much the efficacy of the current, well, to my knowledge, none of it occurred, but that you mentioned the Guantanamo detainees, and sort of that process has been very opaque. And I wonder how much the opaqueness of that process has cut into the efficacy of that as a political maneuver to control or send a message to.
Right. I want to make a distinction between sending a message and indoctrination, or controlling people's views. I think what the government needs to, the narrow message I'm referring to is the message that we're not prosecuting partisan opponents because we're afraid that you, the public, will think that their views are correct and ours are wrong. That's the only message I'm talking about, and the credibility refers to the credibility of that message. I think the Guantanamo Bay cases have been really easy for the U.S. government. And it's just been lucky for them because there's really no support for Al-Qaeda in this country the way there has been support for communists and Nazis and anarchists and socialists over the years, or the South in the North, support for the South during the Civil War. So given that there's no support, that is to say, it would be completely different if one of the parties thought, well, the Al-Qaeda, they got a point and blah blah blah, right? If that were the case, then I think there would be a lot more political agitation about Guantanamo Bay. But even if people in the elite law schools and journalists and so forth don't like Guantanamo Bay, it's simply not a partisan issue. The Democrats haven't made a big deal about it. Kerry didn't make a big deal about it during the election. And the reason why I think it's not a partisan issue is that it's popular. The thought that these people who are foreigners, as opposed to Americans who are part of the political process, who pose a threat to us, can just be put away is not something that makes people, sort of mainstream people, worry in this country. Now, I'm not saying it's a good thing or a bad thing. I'm just making a positive point about why Guantanamo Bay is not as controversial as these political trials in the past, even though it belongs to the same genus. They are as much political trials as the trial of the Chicago 8 was, or the trial of the Jeffersonian Republicans was. Do you have a follow-up?
Yeah, just, I understand that. I understand that there's not a like broad-based Al-Qaeda party in the United States and nobody's jumping up and down for Al-Qaeda, but I wonder, how is the process being used actually scoring any points for the administration or garnering any sort of public support? Because I do think that there are detractions from it, and I think that those, and maybe I'm just selectively perceiving because I am at a school where the constitutional law professors like to jump up and down, what's going on, we're going on a lot, which I think is great. But, so maybe I'm selectively perceiving. So what are the benefits that the United States government is on a rhetorical level receiving?
So here are the benefit. The problem for the United States is that suppose you capture a member of Al-Qaeda in Afghanistan, and let's say he's Osama bin Laden's chauffeur or bodyguard or masseuse or what have you. Okay, so this person, you might think this person is dangerous. Now, you can't prosecute him. You can't bring him to the United States and prosecute him, have a trial, because he hasn't done anything as far as you know. You have no evidence that this person has committed a crime. It's not a crime to be Osama bin Laden's chauffeur. So under the criminal law approach, you just release him and wait for him to commit a crime. And the administration takes the view, which I think is supported by the Democratic Party, or at least the members of the Democratic Party who have power, which is that this criminal law approach is simply not appropriate. Now, during a war, if you're in the middle of a war with somebody, with another country, and you capture a soldier, you're allowed to detain him until the end of the war. And the reason is that he's dangerous. Now, he may not have ever done anything wrong, and this is the odd thing about wars. He may have shot, one of your soldiers, but that's not wrong in war. But even if he hasn't done anything, he could just be somebody who wandered onto the battlefield. You can detain him forever until the war ends. And the reason is that this person's dangerous. So, and it seems, sensible, at least if we have a real war going on. The problem with Al-Qaeda is it's somewhere in between these two extremes. And we're not sure what to do with these people who are members of Al-Qaeda. They've got their membership card and everything. But we can't pin anything on them. Do we just detain them forever? Well, yes, at least in some cases. I'm not exactly sure why the administration doesn't think that's sufficient, just to detain them until the end of the threat posed by Al-Qaeda. It may be because of this concern that there'll never be a clear end. So instead, what they're doing is they're pursuing a middle course. They're having military commissions, which are a compromise between the law enforcement approach and the military approach. And these military commissions have been used in other wars as well, so there's some precedent for them. But the bottom line about this is that if you have a national security threat, ordinary criminal law enforcement, which is developed to reflect the kinds of problems that ordinary criminals pose for national security, not the kinds of problems that foreign terrorists pose to national security. That system is not necessarily appropriate and has to be adjusted to take into account those realities. Is that popular, politically popular? It seems to be, but it's not. That doesn't mean it's the right view or that it's always going to be politically popular. Yeah.
I hope I'm asking an answerable question. You seem to be making the point that one of the reasons political trials of extremists such as Al-Qaeda are popular is because the citizens, the public, doesn't feel that we're next, that you're going to go after mainstream political beliefs. But you mentioned that the Gitmo trials are particularly easy because we see them as foreigners with extremist beliefs. Although some of the trials had to do with U.S. citizens, actually. So I think sometimes the question of whether we worry about us being next can be characterized as a question of these due process rights. Are they rights that are just for American citizens that we think belong to us, or are they due process rights that we believe belong to everybody? And if people to some extent believe that those processes are is the best system, that should be how the rule of law should be in general and not just for American citizens, then that causes concerns that have nothing to do with the fear of being reprised as a mainstream political party in the U.S. So I guess my question is, do you think that the concern of due process rights for all instead of just, us, the American citizens, is just non-existent out there, or do you think, or is that not a problem, or what is your view?
This is right. So 2 points about this. What the view you express is the classic view that Shklar calls legalism, which is that we have these commitments to rule of law values that are general, and they're not tied to any particular political end. And she thinks that's the wrong view, although it's the dominant view. Although I think she'd probably agree with your criticism of American policy. She thinks that rule of law virtues are virtues only to the extent they advance some valuable political goal, such as liberal tolerance or respect for people or human rights, something like that. So she would say, when we think about the extent to which rights in the Constitution should be applied abroad, should be looked at from this political perspective. Now, one might nonetheless draw the conclusion that they should be applied abroad because that is the right thing to do. The instrumental perspective I'm pursuing is, it's just a matter of what the government, what advances American security. And aliens, foreigners, they don't vote. They're not part of the political process. So they are traditionally, both as a matter of constitutional law and policy, they have much less influence and many fewer rights than Americans do. Is that a problem? You have to take, this is a difficult philosophical question, which is debated usually under the rubric of cosmopolitanism. To what extent do the interests and rights of people outside of our country deserve respect in our political system? Okay, so that's a big philosophical debate that I can't give you a yes/no answer to. Yeah?
I have a question about your instrumental account of liberal legalism, and especially the stronger version of it that you suggested you might be interested in making. That the instrumental account gives us a pretty robust explanatory account of how it comes into being or why it's stable. It seems it's got to be right that if the government wants to maximize its power, then it should act so as to be perceived as acting legitimately. And that if it's acting in a political culture that more or less embraces the norms of liberal legalism, then adherence to those norms will tend to maximize its power. Of course, if it's in a divine right of kings setting or a political Islamism setting or a rabid nationalist setting, it'll behave differently. So the functional constraints, so the instrumental constraints on building a government that maximizes its power are of a different sort from, say, the functional constraints on building an airplane that maximizes its speed, because they move across time and across space. And they're actually in dynamic interaction with what the government does, right? So a lot of political trials, as you point out, are partly public struggles over the terms of legitimacy. Execution of Charles I being sort of prime case in point, and one of the inaugural moments of some of the sort of major points of legal liberalism. So what do you do with the where does political culture come from question? I could see how you could have a purely functional account of that, but it might have to be functional for a lot more people and in a lot more ways than the Machiavellian account, solely from the perspective of the government. Or you might look at it as a sort of exogenous cultural factor. I don't know.
Well, yes. So I think there have to be some kinds of cultural predicates that are hard to identify. I think that's right. But I do think that liberal legalism is attractive even to governments that don't exist in that culture. I think so. For example, liberal legalism sort of has flourished in Japan, sort of, But it's not, Japan's culture is not at all like America's culture, not like the West culture. But it was implanted after World War II, and it flourished, at least by the world standards, I suppose. And I think it flourished because there are very strong instrumental reasons for adopting these policies. And I think that the liberal legalism has spread over time because it has very valuable properties from an instrumental perspective for governments that don't care about it. To the extent that the public internalizes it, and I guess people do internalize it, right? To the extent the public internalizes it, then the instrumental side of the theory loses its importance. Although what I do think is that in the United States, which is the most legalistic country in the world, I think, and it always has been, and is certainly a very liberal country in the classical sense of political competition, we relax the norms of liberal legalism when a threat is perceived. Perhaps we wouldn't relax them as much if we didn't have this political culture, but I think in a comparative statics sense, the American practice is consistent with this view that I advance. Yeah?
You said that you feel like the judges, are kind of avoiding, by having the military commissions, avoiding having to try political trials in the criminal, traditional criminal trial sense. Do you think that if we did go to this allowing political defenses to be made in political trials rather than completely having a different type of trial in the military commissions, the public would give the government more credibility? I mean, I know you said that you don't think the public has much opposition to it to begin with, but that there would be more credibility if they were allowed to make political defenses.
That's an interesting thought experiment. Imagine that a law is passed that says, I don't know exactly what it would be, membership in Al-Qaeda is illegal, or see, it has to be very broad, because the key problem for the United States is that these people, and this was the problem during the Smith Act years as well, is that these people haven't done anything yet. There are people who, or we can't prove that they've done anything. So we need a law that simply identifies people who are dangerous. That's really hard to do, to draft a law that says anybody who's about to overthrow the American government or wants to really badly and is beginning to cooperate with other people. You try to draft a law like that and it becomes so broad that mainstream people feel like they're going to be swept in. But we could imagine that happening, right? And then the courts would have to decide whether to enforce it. And we'd be back to Brandenburg and all these cases. Well, did this person actually engage in harm? Or maybe Brandenburg was a mistake after all, and we should go back and say that as long as there's a reasonable view that this person is about to commit harm, and the harm is sufficiently serious, then the government can convict him. And so you can imagine this all happening. And then the question would arise, would these trials be more successful if the defendant were allowed to make political defenses? Well, I suppose I would say yes, it would help the government, because that would help, at least in some cases, make it clear. If the person said, if the defendant says, look, I thought the 9/11 attacks were terrific, and I think the United States is a terrible country, and I'm looking forward to the day that Islam rules the world. Nobody's going to think the government is going after this person because he's a major donor to the Democratic Party, right? But if the person says, the problem for the government is the person might just say, look, I didn't do anything yet. Why are you, and yes, I believe in Islam, and I think America has done some bad things, but I'm not about to do anything dangerous. What happens when that occurs? That's the danger. So when you let the defendants testify, this is why. This is really the most interesting thing, one of the most interesting things about Nuremberg and the trial of Saddam now. You let the defendant testify, you're taking a high-stakes risk that he'll hang himself. Basically, you're hoping he'll hang himself, that he'll say things that are so outrageous and ridiculous that the world will thank you for crushing this person. But the danger is that the person will be clever or not or whatever, that the person will instead simply say, you do things that are as bad as what you're accusing me of doing. That's the successful defense. And you're just using me as a pretext for extending your power. Then the trial will be a failure, at least if people believe that. Okay, Neil?
It's good to see you, Eric, and it's great to have you at Duke. You never fail to disappoint, but I'm going to limit myself. Just two quick comments and a question. First comment, I guess just hearing you talk right now, I wonder if there's a metaphor for confirmation hearings as political trials. And one side hoping that the nominee hangs himself, the other side hoping that he acquits himself. Well, something to think about. I wonder whether you need a more refined conception of political competition, because in a certain sense, political competition is bedrock to our system, and in another sense, it's not at all. Right? It's getting impossible to beat an incumbent. Right? So in that sense, political competition is not bedrock. I think the Democrats and the Republicans are both in bed together with respect to that, right? and there are other ways in which you would call it a political trial because they're going after one another. But I don't think political competition writ large is really a bedrock feature of our system. At least the public doesn't seem concerned about it. I think my biggest concern and my question has to do with your definition of political trials. It seems to me, and you probably know this because you called it a rough definition, it seems to me it's conceptually unstable. Right? You see, at the one end, you seem to say that it's a political trial if you go after someone for their political views, but not if you're going after someone because of a perception of public threat or dangerousness.
No, no, no.
Well,
I define it broadly to include both of those.
So whether it's Brandenburg or Dennis, it's a political trial.
Right.
So whether you're
Because
within the hard core of the First
because
Amendment.
there's no law. I mean, the simple-minded, literal reason is that there's no law that. I mean, there might be a pretext of some sort, but there's no law against political opposition that is being enforced. You're going after somebody because he's dangerous, either to the government in a political sense or to the public in a future threat sense, but not because he violated a law.
So if someone is about to set fire to the law school, or someone is talking to a crowd to go immediately set fire to the law school, that's a political trial.
No, well, no, there are laws against that. I mean, it depends. You know, it's.
No, but the question is whether those
right.
laws violate the First Amendment or not.
Right.
I
Right.
mean, you can't just say there are laws and there
That's
aren't.
why there usually aren't laws, because the First Amendment prohibits laws that prohibit political opposition per se. But yes, if there's some immediate harm, you can try the person for disturbing the peace or what have you.
It still seems to me that you're not talking about a difference in kind between what constitutes a political trial and what constitutes a liberal legalistic trial. Whether the harm is at some future time based on ideology or whether the harm is immediate, you're still talking about circumstances under which you can target speech and circumstances under which you can't. I don't see why one is political and one is not.
Okay, that's helpful. Let me quickly give you responses since we're about out of time. Confirmation hearings, yeah, that's the whole point. But when trials begin to seem like debates between different ideologies, then it begins to seem like what we hear in the House or the Senate. That's what makes them political. That's how you can tell when something's a political trial, when everybody starts arguing about whether the government is bad or not. And that's what happens in virtually all of these cases. As for whether there's real political competition, I mean, I guess I don't want to make any strong assertions about that. I think that the type of trials we have are parasitic on the political system we have. So if we really live in an implicit authoritarian system, then of course there are political trials, just the way real authoritarian systems have political trials all the time as a way to crush their enemies. Your last point is important, and it is actually, I have been simplifying a little bit. These First Amendment line of questions struggle with this idea of when does a harm end and mere political opposition begin. But it's clear that you can draw the line somewhere. That seems to be the case, that we can make a distinction between people who are about to harm other people and people who are simply advocating a view that others find undesirable. And the way we do that, and what's really the bedrock part of this, is what's part of the public consensus and what isn't. So there's a public consensus that you shouldn't set fire to libraries and that you shouldn't incite riots. You shouldn't harm other people. You shouldn't damage property, that sort of thing. There's no public consensus about whether communists are dangerous, whether just being a communist and espousing communist rhetoric harms other people. Okay, so the people who want to go after the communists make the claim, yeah, no, this is harmful. It's going to be harmful once they get power and they're helping the Soviet Union and so on and so forth. And then the more legalistic people say, look, they haven't harmed anybody. And the only way we could pass a law that would make what they're doing illegal is by essentially outlawing political opposition or political competition. So what's going on here, there's an implicit dividing line between what everybody agrees on and what is legitimate and where there's legitimate debate. And that's the First Amendment draws that line. And in political trials, that line is debated to some extent. People are arguing about where that line should be drawn.
So political trial is what society views is a political trial, and that view could change or vary across societies. That's what you're appealing to with public consensus.
Partly because, yes, partly because Right. I mean, this comes up in a lot of these cases. So somebody, clearly violates the law. They break into a building and destroy records. Well, it turns out this is a draft. This is a draft and a draft. What do they call it? A military recruitment office, or an office where the draft is processed. And suddenly, some people say there's nothing wrong with that because the Vietnam War is a worse evil than destroying some property. Now, what's going on in that case is that the public consensus about not destroying property and entering government buildings is breaking down in light of this greater ideological disagreement about government policy. And when that happens, when there's a sufficient enough division in society, at the extreme you get civil war. But prior to that extreme, what seemed like ordinary trials become converted into political trials because the line between what's legitimate behavior and what's considered the proper realm for political debate has itself become controversial.
Thank you very much. There's a reception up front.